5 seconds to go. Start. The High Court of Judicature at Bombay had specifically held, as affirmed by a 3-judge bench decision of this court, that had punishment been provided for continuing unlawful activity, the submission that while punishing, it treats unequals as equals may carry weightage. Stop. The High Court, as affirmed by this court, upheld the validity of the provision defining continuing unlawful activity only because the act did not provide any punishment for that activity. Stop. In para 27 of Bharat Shanti Lal Shah Supra, the High Court made it explicitly clear that the limited purpose of continuing unlawful activity was to see the antecedents of the person and not to convict. Stop. Section 2 defines, not only the offence of organized crime but also the other terms used in the Makoka. Stop. What is material is the definition of offence of organized crime and not the definitions of other terms included in section 2. Stop. Had the term continuing unlawful activity been synonymous with organized crime, it would not have been necessary for the legislature to include or provide for two definitions. Stop. It would have been sufficient to provide for only one definition of continuing unlawful activity and make that activity punishable. Stop. The definitions in clauses D and E respectively of subsection 1 clearly indicate that one of the components of organized crime is continuing unlawful activity and, therefore, organized crime is something more than mere continuing unlawful activity. Stop. Para. The High Court thereafter proceeded to observe in paras 47 to 53 respectively as under, para. The court then rejected the objections to the constitutional validity of the definition. Stop. It is thus clear that apart from previous charge sheets, there has to be a continuation, an activity to which Makoka is applied. Stop. Para. This fortifies the conclusion that mere proof of filing charge sheets in the past is not enough. Stop. It is only one or the requisites for constituting offence of organized crime. Stop. If only the past charge sheets were to be enough to constitute offence of organized crime, it could have offended the requirement of Article 21 of the Constitution and possibly Article 22 as well, bracket start, and in any case section 300 of the CRPC, bracket close, stop. Had these judgments of the Supreme Court and division benches of this court been cited before the learned single judge deciding Amarnath versus State, the learned single judge, without doubt, would not have held that the matter was simply one of an arithmetical equation. Stop. The said judgment cannot be reconciled with the judgments or division benches in Jaising versus State, which I am bound to follow. Stop. Para. It is not necessary to go into the implications of the expression prosecuted and punished used in Article 22 of the Constitution. Stop. Section 300 of the CRPC itself clearly bars a fresh trial for the same offence. Stop. Section 21 of Makoka, which prescribes modified applications of the code to offences under Makoka, does not make provisions of Section 300 of the CRPC inapplicable. Stop.